The unwritten law, undang-undang tidak bertulis. Okay, so the first part of unwritten law is English law, undang-undang Inggeris. As per I mentioned to you that English law, okay, for English law, all the Commonwealth country will apply English law. So English law, the law which comes from UK, um, and um, and we already discussed on law of thought. Okay, law of thought. So under English law also we have common law. Common law. If you refer to Malay book, okay, you still find the word common there. Okay, it's just law ditukar kepada undang-undang, okay, undang-undang common. Okay, so common tu tukar perkataan jadi biasa ke tak? Okay, it's still common. Perkataan common tu adalah nama undang-undang yang datangnya daripada UK. Okay, for Commonwealth country, that's why nama dia common. Okay, tak jadi biasa ke tak lah. Okay, still undang-undang common or common law. And it develops, okay, from judicial decision. This one is considered as the first stage of English law. So you nampak kat sini from common law, later on it will be developed to equity, then the latest type of English law is statute. This slide shows you the development of English law, perkembangan undang-undang Inggeris, starting from common law, then it's upgrade to equity, later on to statute. So if there is conflict, sekiranya wujud konflik, okay, if there is conflict between a common law and equity, so we look at what is the latest version of law. Jadi sekiranya ada konflik di antara common law dan equity, so equity will be prevail. Equity will win. Maksudnya equity akan menang lah. Sebabnya equity is considered as the latest law compared to common. But if there is conflict, okay, there is a dispute between the common law, equity and also statute. So statute will prevail. Statute paling latest. Kita lihat di mana undang-undang mana yang paling terkini. So the first stage, okay, of English law is common law, okay, starting from a Renaissance, okay, pada masa kebangkitan Renaissance, okay, pemodenan yang berlaku di UK. So common law wujud, develop from judicial decision, keputusan kehakiman. Okay, apa yang diputuskan oleh hakim yang terdahulu akan diikuti oleh hakim yang terkini. What has been decided by the previous judge will be followed by the current judge, okay, who are sitting for that case today lah. Okay, kita akan lihat judge yang baru akan lihat apa keputusan yang diputuskan oleh judge yang lama sebagai panduan dan sebagai presiden. So judicial decision also can be referred as judicial precedent. So established before statute was passed. Diwujudkan sebelum adanya statute. That's why saya kata statute tu dianggap sebagai yang terkini. Common adalah undang-undang yang paling awal wujud di UK. Okay. Dan seterusnya, okay, we go to equity. Equity, okay, come from the word equal. Equal means that just and fair. Okay, equal. Sama maksudnya, sama level, equal, persamaan. So kat situ tak ada orang yang lebih, tak ada orang yang kurang lah. So it refer to just and fair. Okay, lebih kepada keadilan. And content rules and principle as supplement to common law. Okay, mengandungi peraturan dan juga prinsipal yang dianggap sebagai supplement, okay, menyokong kepada common law. So equity is considered as latest compared to common law. That's why lah dia dianggap sebagai okay, supplement kepada apa yang kurang, okay, what has been lacked in the common law, apa yang kurang, apa yang dalam bahasa perundangan, okay, we called it as lacuna. In the legal term, we know it as lacuna. Okay, what is lack? Okay, lacking. Okay, in the common law ataupun loophole in the common law. kita katakan ini sebagai lacuna. This one is a legal term. Okay, come from Latin word, lacuna, maksudnya loophole. Apa lompong, apa kekurangan yang ada dalam common law, kemudiannya dilengkapkan oleh equity. So equity is considered as a remedy and also recognized common law. Equity dianggap sebagai baik pulih, melengkapkan apa yang kurang pada common law, dan ianya diiktiraf oleh common law, okay, sebagai pelengkap. Later we have a statute. Statute. So statute ni sebagaimana yang diletakkan di common law, dikata established before statute were passed. So statute tu peringkat ketiga kepada perkembangan undang-undang Inggeris. Statute ni refer to act, enactment or ordinance. Statute tu akta lah. Okay, whatever been passed by the government, yeah, either it is act, enactment or ordinance, that one is statute. Okay, law enacted by parliament, supplement to common law also, melengkapkan apa yang kurang kepada common law. Muhammad Isma
trying to follow up his sensational solo goal against Bielefeld on Saturday. 0-0 and the break, getting Terzic on the right there was Dortmund's cup-winning coach last season. The cup-winning captain Marco Reus is still on the bench. There are other quality reserves.
Isma tengok apa tu? Bola ke apa?
Saya data.
Kita tengok filem apa pula?
Kat dengan television tu.
Kat dengan television. Okay, tiba-tiba je. Right. Okay, so that one is English law. So faham bahawa apa yang ada dalam undang-undang negara yang dikenali sebagai Commonwealth country adalah sama ada sebahagian ataupun lebih daripada sebahagiannya adalah berdasar daripada undang-undang Inggeris. Okay, for example, in Malaysia, 80% of our law come from UK, but later on we modify and also we amend that law according to our custom and also not to contradict to our Islamic principle lah. Apa saja yang bercanggah dengan masyarakat kita akan buang lah. Okay, so that's why even kita kata kita mengguna pakai undang-undang Inggeris, but not all English law kita akan ambil lah. Ada juga, ada banyak lah undang-undang Inggeris yang kita biarkan kat sana, kita tak ambil, tak import masuk ke tanah Melayu, ke Malaysia. Ada undang-undang yang bagus kita ambil, undang-undang yang tak bagus kita tinggalkan. Okay? For example, you know that in UK membenarkan perkahwinan sesama jenis, and they also recognize LGBT, okay, lesbian, gay, transgender, bisexual, whatsoever ni, diorang, okay, they recognize that group of people. But in Malaysia, we are not recognized the LGBT, and we are not importing the law which relates to the permission of or approval of marriage between the same gender. Kita tak ada undang-undang tersebut. Walaupun kita kata kita menggunakan pakai undang-undang Inggeris. Undang-undang yang tak bagus kita tak ambil. Especially the law which contradict to our custom, contradict to Islamic principle and also to our nation lah. Okay. Tapi ada juga undang-undang yang bagus tapi kita tak bawa masuk ke Malaysia. For example, kalau kata in UK they have act which act of welfare, okay, for homeless people. Okay, memang ada akta khusus melindungi, protect the homeless person. Maksudnya orang yang tak ada rumah tu ada akta khusus. Kenapa? Kalau kita lihat dalam TV, dalam cerita, the government give them kupon makan, and also give them toiletries, kelengkapan toiletries, dan boleh beratur di mana-mana kedai untuk dapatkan makanan free dan sebagainya, because the government protect them, and there also special place for homeless. Ada kawasan yang digazetkan, yang diwartakan untuk orang yang tidak berumah untuk tinggal dekat situ. Mereka ada komuniti mereka. Okay. Sebabnya ada akta khusus yang melindungi golongan yang tidak mempunyai rumah ni. That's why mereka boleh they also enjoy certain privilege okay, as homeless people. Sebab ada protection khusus untuk mereka. Dan undang-undang tu dikeluarkan oleh Government of UK dan diguna pakai. Tapi undang-undang tersebut kita tak bawa masuk ke Malaysia. Maksudnya ada juga undang-undang yang bagus lah, kita tak bawa masuk. Jadi kalau kita lihat di Malaysia, there's a debate about the issue of homeless. Ada mereka yang mengatakan bahawa homeless people ni tak perlu dibantu. Kalau dibantu makin ramai kewujud homeless. Tapi ada juga kita lihat NGO yang memang bekerja keras, yang memang everyday turun untuk bagi bantuan kepada homeless. Okay, since not get full support from the government, kan. Tapi kita lihat lately government pun mula dah bekerjasama dengan NGO. Okay, sediakan tempat untuk homeless datang, tinggal sekejap dan sebagainya. Tapi tak boleh tinggal lama lah, because kalau dia orang tinggal lama, they have to pay for the place. So kita nampak ada inisiatif untuk itulah. Okay, bila dilihat di mana kebanyakan aktiviti which is relates to homeless ni diterajui oleh NGO. Sekejap. Okay, so okay, that's all about the English law. Okay, anything that you want to ask about the English law before we go to application of English law in Malaysia? Kita lihat macam mana, kenapa, why we import English law to Malaysia. Do you have any question regarding the common law, equity, and also statute? So you have to remember that if there is dispute or any contradiction between common law, equity, and also statute, you have to look at what is the latest law. Okay, apa undang-undang yang paling terkini. So that law will be prevail, okay, compared to the old version of law. Okay, so application of English law in Malaysia. Kita nak lihat macam mana, kenapa undang-undang Inggeris ni dibawa masuk ke Malaysia. Mestilah ada akta khusus yang membenarkan the application of English law in Malaysia. So we base on Section 3 and Section 5 of Civil Law Act 1956. So please highlight this section 3 and Section 5 of Civil Law Act 1956. Kita menerima Undang-Undang Inggeris di Tanah Melayu because of these two sections, these two provisions. Section 3 and Section 5 of Civil Law Act 1956. So Section 3 is refer to general application of English law, meanwhile Section 5 refer to law relates to business, trade, whatsoever. Okay, sorry class. Okay, sorry class, banyak gangguan pula hari ni. Okay, in fact because all the lecturers have to be in the office. Okay, right now Johor already in fasa 4. Okay, phase 4. So some of the students who are having lab or studio project dah masuk dah. Okay, maybe for you yang social science lah belum ada, tapi lecturer have to be in the office. Cuma pagi tadi I dekat office lah, cuma bila kelas. Okay, I lebih prefer berada di rumah because internet dekat rumah lagi okay. Sometimes dekat UTM ni ada gangguan banyak sikit. Okay, sampai sekarang lah macam ni lah. Okay. Office pun call okay during office hour ni. Okay, so we go back to our discussion. Okay, referring to application of English law. Okay, so please highlight section 3 and section 5 of Civil Law Act, okay, 1956, di mana section 3 relates to general application of English law. Whatever law which is considered as general application. So law referring to evidence law, criminal law, civil law, civil procedure, criminal procedure, what else? Probate, about will. Okay, so that one is general application of English law. But for law which is related to business and trade, okay, undang-undang yang berkaitan dengan perdagangan, perniagaan, okay, we will refer to section 5. Section 5 yang Civil Law Act 1956 yang membenarkan undang-undang Inggeris baru masuk ke tanah Melayu. So all the law which relates to business, for example, contract, sales of good, hire purchase, maritime, shipping, insurance law. So undang-undang ini partnership, company, so undang-undang yang berkenaan dengan business lah. So all of that law, okay, kita guna pakai law yang English law yang berkaitan dengan business dan juga trade berdasarkan section 5. So for general application relates to section 3 and for business and trade section 5. Okay, so section 3 subsection 1, kenapa kita terima undang-undang Inggeris in the absence of local legislation? In their absence. Okay, if our law is lack on that lah. Sekiranya kita ada kekurangan, if we are lacking on that, or if our law having loophole on that, so kita ambil undang-undang Inggeris in the absence of local legislation. Sekiranya undang-undang kita tiada, maka kita ambil undang-undang Inggeris. If our law already have that version of law, so kita tak ambil. Kita tak ambil. Jadi kalau kata undang-undang kita kurang, undang-undang kita masih lemah, masih lagi dalam pendrafan dan sebagainya, dan we look at the English law dah lengkap dah, so we refer to the English law in the absence of local legislation. And in Peninsular Malaysia, the courts shall apply the common law of England. So you lihat kat sini. In Peninsular Malaysia, I underline there, common law of England and also rules of equity will be applied. Apa saja undang-undang yang berkaitan dengan common law, okay, dan juga rules of equity akan diguna pakai di Malaysia bermula pada tarikh 7 April 1956. Starting from 7 April 1956. Okay, we know that the development of English law tadi consists of common law, equity and also statute. So kat sini you tak nampak. Okay, you nampak kat sini tak ada statute. So for Peninsular Malaysia, Semenanjung Malaysia, okay, Semenanjung Malaysia, so please everyone look at your map lah. Semenanjung Malaysia consists of negeri apa? Okay, exclude of Sabah dan Sarawak. Negeri yang berada di Semenanjung Malaysia mengguna pakai common law of England and also rules of equity. But okay, however, in Sabah and Sarawak, the courts shall apply English common law, rules of equity together with statutes of general application. So in Sabah and Sarawak, they not just apply common law and equity, but they are also importing statutes. Akta, okay, whatever been passed in UK, they also use it in Sabah and Sarawak. That's why for advocate and solicitor, untuk lawyer, untuk pengamal undang-undang, if they want to practice in Sabah and Sarawak, they have to sit for a special exam. Okay. For those from the advocate and solicitor from Peninsular Malaysia who wants to practice in Sabah and Sarawak, they have to sit for special exams. Sebab undang-undang di sana berbeza. Sebab dimasukkan dekat sini statutes. Okay. Which is in Peninsular Malaysia, we just apply common law and equity. But in Sabah and Sarawak, they also include statutes. Okay, from English law also been applied there. So in Sabah, okay, for the application of English law, equity, and also statutes, starting from 1st December 1951, okay, bermula pada 1 Disember 1951. Meanwhile, okay, for Sarawak, starting from 12 December 1949. So look at the date. Okay, look at the date. Sarawak is considered as the earliest state who apply English law, English law, i.e. common law, equity, and also statute in Malaysia. 1949 ni kita lihat kepada dinasti Brooke. Okay. Raja Brooke di pemerintahan Raja Brooke di Sarawak bermula 1949. Okay, dan bermulanya undang-undang diguna pakai undang-undang Inggeris at that time. And then di Sabah starting from 1951, 1st December 1951, and in Peninsular Malaysia 7 April 1956. So please remember, okay, the date and also what kind of English law, okay, been applied, okay, because for Peninsular Malaysia and also and for Sabah and Sarawak ada perbezaan di situ. And the reason, okay, tadi kita bincangkan bahawa kenapa kita guna pakai undang-undang Inggeris di Tanah Melayu bila mana undang-undang di Tanah Melayu ataupun Malaysia ni tak ada undang-undang tersebut. In the absence of local legislation, bila undang-undang tempatan tiada, maka kita ambil undang-undang Inggeris. And the second reason is suitable to the local circumstances. As long as English law, common law, okay, English law, i.e. tadi common law, equity, and also statute, suitable to the local circumstances, not contradict to our custom and also not contradict to our Islamic principle. Bagaimana ia tak bercanggah, kita akan ambil undang-undang Inggeris tersebut. Kita tak kisahlah undang-undang common law ke, equity ke, statute whatsoever, as long as ianya tidak bercanggah dengan keadaan masyarakat setempat, tak bercanggah dengan adat and also tak bercanggah dengan Islamic law, undang-undang Islam. Okay, for example, dalam case Chua Chunyo and also Spottiswoode, this one is very old case. You can Google this case, Chua Chunyo versus Spottiswoode. Okay, very old case. Cuma saya nak highlightkan a little bit back of this case lah. Okay, Chua Chunyo. This case happened during Federated Malay State. Okay, this case has been reported in FMSLR. Federated FSMLR. Federated Malay State Law Report, FMSLR. Okay, I put it in the chat. Okay, box FMSLR. Federated Malay State Law Report. Very old case. Chua Chunyo versus Spottiswoode. Okay, so Chua Chunyo versus Spottiswoode. Okay, during this or you can also Google this case by the name of the Six Widows case. Six Widows case. Nama dia, nama lain dia lah. Untuk case Chua Chunyo versus Spottiswoode ni nama lain dia Six Widows case. Because during the old days, okay, one of the custom of Chinese is kalau kata undang-undang Islam membenarkan lelaki untuk kahwin. Okay, membenarkan lelaki kahwin berapa? Kelas? Undang-undang Islam. Lelaki boleh kahwin sampai berapa? 4. Okay. Atika cakap boleh kahwin sampai 4. Okay, so undang-undang Islam membenarkan lelaki Muslim untuk kahwin sampai 4, tapi during the old days, untuk Chinese custom ni membenarkan lelaki Cina untuk kahwin sehingga 20 orang membenarkan. Sampai at that number. 20. Membenarkan sampai 20. Kahwin sampai 20 orang. Tapi dalam kes Chua Chunyo ni dia kahwin sampai 6 je. Six Widows case. That's why nama dia Six Widows case. So, bila mana kedatangan Inggeris ke Tanah Melayu when English come to Malaya, okay, at that time, they feel that okay, that situation is considered as a violation to human rights. Again, they feel that is a violation of human right, especially to women rights lah. Hak orang wanita pada waktu tersebut. Kenapa boleh ada satu custom yang membenarkan lelaki sampai boleh kahwin sampai 20 orang. Okay, so mereka merasakan ini satu keadaan yang against human rights, especially for women rights, hak wanita. Jadi bila that's why case ini kita namakan Chua Chunyo, the person yang ada 6 isteri, and the Spottiswoode ni English lah. So Englishman bawa kes ke mahkamah menyatakan bahawa tidak wajar untuk seorang lelaki kahwin sampai 6. Dalam kes ni Chua Chunyo ni kahwin sampai 6. Tapi because it is custom at that time, okay, because it is custom, and we know that custom bila mana ia dianggap sebagai adat, maka ini mestilah sesuatu yang been recognized among the community, adalah sesuatu yang diiktiraf di kalangan masyarakat pada waktu tersebut. Okay, so bila mana dinamakan custom, maka ia tidak boleh diubah pada waktu tersebut lah. Okay, but during that time. So Spottiswoode kalah. Okay, tak menang lah dalam kes ini bila dia bawa kes against Chua Chunyo. Sebabnya kita tahu bahawa kita membenarkan undang-undang Inggeris dibawa masuk ke tanah Melayu atas dua sebab. Okay, in the absence of local legislation, and also that law, whatever law, from English law tadi, must be suitable to the local circumstances. If the law contradict to our custom or to our Islamic principle, then we will reject the law. Jadi bila mana undang-undang tersebut bercanggah dengan undang-undang adat, maka kita tak terima lah. Bila mana Spottiswoode nak perkenalkan undang-undang yang hanya membenarkan dalam perkahwinan ni yang legal wife hanyalah seorang sahaja, tak boleh lebih daripada tu. Tapi custom membenarkan, maka case bring by Spottiswoode against the Chua Chunyo kalah. Okay, gagal. So kita nampak kat situ custom prevail. And then we go to section 5. Okay. Just now, kenapa ni? Oh, saya tak baca lagi kat bawah ni. Tak nak baca dekat bahagian chat ni, baru nak baca ni. Oh, Fakhrul Aziz cakap setia pada yang satu. Baguslah, setia pada yang satu. One is enough. Tak perlu ramai-ramai lah. Bukannya konsep the more the merrier ke apa kan dalam perkahwinan ni. One is more than enough. And then English commercial law, okay, for section 5. Tadi kita bincangkan section 3 about the general application. Right now we come to the section 5, application of English commercial law. So whatever law relates to business or trade or commerce, okay, for example, sale of goods, hire purchase, contract, insurance law, maritime law, shipping, company, partnership law, agency law. So undang-undang yang berkaitan dengan commerce lah, perdagangan. Ianya berdasarkan Section 5. Section 5 yang membenarkan Section 5 of Civil Law Act 1956 yang membenarkan kita menggunakan pakai undang-undang Inggeris. So Section 5 subsection 1, okay, the principles of English commercial law to be applied in Peninsula Malaysia. Dia kata bermula pada tarikh 7 April 1956. So kalau nampak kat sini the same date lah. Okay, sama date dengan Section 3 tadi untuk Peninsula Malaysia. Cuma Section 5 ini even dia kata Peninsula Malaysia, tapi ada dua negeri yang terkeluar, iaitu Penang and Malacca. Penang dan Melaka terkeluar, okay, daripada perkara yang melibatkan penggunaan undang-undang Inggeris yang berkaitan dengan perniagaan ataupun commerce. So Penang and Malacca join Sabah and Sarawak. Penang dan Melaka ni join Sabah dan Sarawak, di mana Section 5 subsection 2 dia kata, okay, the principles of English commercial laws shall apply in the states of Penang, Malacca, Sabah and Sarawak at the corresponding period if such a questions or issue had arisen or had to be decided in England unless local law is existed. So kalau kita lihat sampai sekarang ni untuk commercial law for Penang, Melaka, Sabah and Sarawak, they can just take whatever new law being passed in UK. Tapi bergantunglah sama ada undang-undang tersebut, okay, kalau kata undang-undang tersebut terlalu baru dan kita tahu bahawa local law tak ada, then mereka boleh guna pakai. Tapi kalau we already have that law, then they have to refer to the local law. So the reason is still the same in the absence of local legislation and also subject to the suitability of the local circumstances, subject to our custom, subject to our Islamic principle. Okay, so one case lah to discuss on the English commercial law yang di mana kita nak lihat bahawa kita akan guna pakai undang-undang English selagi mana undang-undang tempatan tiada dan juga selagi mana undang-undang tersebut tidak bercanggah dengan undang-undang tempatan. Okay, as long as it does not contradict to our Islamic law and also to custom, suitable to the local circumstances. Dalam kes Sheikh Sahid bin Abdullah Bajarai versus Sokalingam, okay, once English bertapak di tanah Melayu, they invade Malaya, mereka cuba memperkenalkan sistem perbankan. Okay, they want to introduce banking system. Pada masa dahulu, okay, pernah tengok cerita P. tak? Tahu tak siapa apa ni? Chetty. Tak pernah kenal. Nanti cerita P. Chetty. Yang dalam cerita P. tu Chetty ni kalau kita nak katakan sekarang ni nak disamakan macam Along lah. Tapi Along sekarang kejam. Tapi kalau Chetty ni dalam cerita P. bila P. meninggal dalam cerita tersebut, Chetty pun menangis sama. So maksudnya Chetty ni baik hati lah. Chetty ni an Indian man yang pakai baju putih dengan payung, known as banker lah at that time. Bila mana orang tempatan tiada duit pada waktu tersebut, boleh pinjam daripada Chetty. Because at that time we don't have any proper banking system. Okay. So once English come to Malaya, they want to introduce banking system. Jadi nak pecahkan custom ataupun adat dan tradisi yang diamalkan oleh orang penduduk tanah Melayu at that time. So sedangkan penduduk pada waktu tersebut meminjam wang daripada Chetty. Dan in fact, okay, we have Akta Chetty di Malaysia. Kita ada Akta Chetty di Malaysia berkenaan dengan akta peminjaman wang lah. Tapi memandangkan Chetty sendiri sekarang ni dah pupus, maka akta tersebut kemudiannya di-delete. Dimansuhkan, abolish, okay, due to the non-existent of Chetty ni. Dah tak ada dah Chetty. Chetty ni kalau bahasa Inggeris dia macam okay, this one, Chetty. You can Google this word. Okay, Chetty. The one, the person that can lend us money, okay, at that time, during old days lah. So bila Inggeris ingin perkenalkan banking system ni, Sokalingam ni Chetty. Okay, Sheikh Sahid bin Abdullah Bajarai orang kaya lah. Okay, yang dapat mandat daripada Englishman at that time untuk perkenalkan banking system, okay, di tanah Melayu. So nak cuba hapuskan sistem Chetty. So what do you think? Okay, if we look at the reason, okay, subject to suitability to the local circumstances at that time, okay, we recognize Chetty ni sebagai sebahagian daripada adat, okay, sebagai tradisi budaya at that time. So bila mana Inggeris cuba nak hapuskan Chetty, you rasa berjaya atau tidak? Do you think? What do you think? Ni kes lama ni, during Federated Malaysia juga, negeri Selat at that time. So what do you think first? Agaknya berjaya atau tidak? Tadi kalau cuba nak masukkan adat, okay, masyarakat ada kat sini menyatakan satu daripada adat masyarakat tempatan membenarkan kahwin sampai 20. English cuba nak masukkan tapi tak berjaya sebab ni contradict our custom. So sekarang ni dalam situasi kita terima, kita memang recognize ceti sebagai orang yang boleh pinjamkan wang dalam keadaan terdesak. So once English can to tanah Melayu, mereka cuba nak hapuskan. You rasa berjaya atau tidak? Ni dekat chat pun tak ada jawapan. Suara pun tak keluar. Kelas. Kilim ni cakap maybe no. Okay, so tak berjaya. Dia tak berjaya untuk menghapuskan sistem ceti at that time. Tapi because of times goes on, masa berjalan, sistem ceti kemudian dia terhapus dengan sendirinya bila mana kita lihat bahawa sistem perbankan dengan pelbagai skim yang di-offer oleh bank kemudiannya dengan sendirinya terhapus sistem ceti walaupun during old days kita ada akta ceti. Sebab nak pinjam wang ni pun mesti ada akta dia yang membenarkan kenapa ceti itu wujud. Macam juga Along sebenarnya dilindungi sebab ada akta yang membenarkan perniagaan yang memberi pinjaman wang. Tapi cuma dari sudut kekejaman tu, dari sudut memeras ungkut, dari sudut simbah cat orang yang tak mampu bayar dan sebagainya, simbah cat dekat rumah dan sebagainya, that one is not recognized under law. Tapi dari sudut bisnes, bisnes peminjaman wang tu dibenarkan. That's why lah mereka exist. Sebab tu lah mereka wujud. Perniagaan yang memberi pinjaman wang ni beside of bank.
Doktor,
Yes.
so kirakan kalau anything yang consider as custom and then tapi dia asalnya is not inclusive in the English commercial law tu, the custom will still override the English law lah kan?
The custom still override. But that one is during old days. Tapi sekarang ni tak lah. Okay, during old days. So kalau if the case been brought again today, the decision will be different. Right?
Okay.
So bila mana kes tersebut dibicarakan pada waktu tersebut, memanglah pada waktu tersebut kalau katakan merujuk kepada sistem ceti ni diiktiraf. At that time cetia ni diiktiraf tapi kemudiannya terhapus dengan sendirinya dan kita tahu bahawa sistem perbankan negara kita pun dah makin strong. Jadi kalau kata dibawa sekarang ni memang sistem ceti ni tak diguna pakai lah. Sama juga kalau kata kita nak menolak Along dalam sistem peminjaman wang pun, kalau kata nak bawa kes ke mahkamah, we have to know that in fact perniagaan yang dibuat oleh Along itulah satu perniagaan yang recognized by law. Perniagaan yang melibatkan peminjaman wang itu adalah diiktiraf. Cuma yang kita tak setuju, what we are against ialah referring to the oppression, kekejaman yang mereka lakukan kepada peminjam wang, yang ada yang kes melibatkan sampai kes bunuh dan sebagainya bila orang tak mampu bayar, ataupun dipukul dan sebagainya. That one yang kita tak suka. Tapi dari sudut peminjaman wang, memang mereka ada bisnes yang registered in fact. Okay. Soalan dekat bawah tu, do we rely totally on English common law today? What do you think, class? If you look at the factors study, factors study refer to the in the absence of local legislation, we accept English law, i.e. common law, equity, statute, as long as the law not contradict to our custom, not contradict to our Islamic law, and in other words, it is suitable to the local circumstances, and also in the absence of local legislation. So, in the current situation now, dalam keadaan sekarang ni lah, do we rely totally on English common law? What do you think?
No, because it's
Mm-mm.
me-
Yes, Atika cakap apa?
it is not fully English
Mm-mm.
commercial law.
Okay, so we are not rely totally on English commercial law today because we have our own law. We have our version of contract, Malaysian Contract Acts, for example. Okay, so right now we've discussed from the Malaysian legal perspective. Okay, we have Malaysian contract law. We have sales of goods, okay, law, and we also have hire purchase. So we have our own law. So that's why we are not rely totally on English commercial law lah. Kita dah ada undang-undang kita sendiri unless okay we are lack on that. Okay, for example, in terms of e-commerce law, okay, we are still lacking on that. So that's why we're referring to English law regarding the e-commerce. But in 2016, we already have e-commerce, okay, e-commerce law, okay, in Malaysia. So bila mana kita dah ada undang-undang sendiri at that time 2016, so we will refer to our version of law. Kita tak refer lah kepada undang-undang Inggeris lagi sebab kita dah ada. Kalau kita tak ada baru kita refer. Cuma mungkin our law is sometimes when we look at the provision and also the contents of law, we are lag behind. Okay, we are lag behind. Some of the provision is not stated or not drafted clearly. Still need a discussion, further discussion, or we must have be supported by any other law, okay, to convince the section. Itu yang kadang-kadang berlaku. Ya. Kalau you can Google, okay, e-commerce law in Malaysia, E-Commerce Act, okay, ECA 2006, known as ECA, ECA 2016. We section tak banyak pun ada kat dalam tu. Okay, only 15 or 18 sections in that act. So if we compare to the full version of UK, okay, e-commerce law, memang lengkap lah, okay, memang lengkap. So in that situation, okay, kalau kata kita lag, so we have to do amendment and also improvement, okay, in order to make sure that the law is fully can be fully utilized. Kalau tak, kita terpaksa refer kepada undang-undang lain untuk settlekan one case lah. Sometimes case which relates to e-commerce, we also have to canvass a certain law which relate, for example, for give a decision to e-commerce law. We refer to e-commerce act, we refer to contracts, we refer also to sales of goods act in order untuk selesaikan satu case. Terpaksa canvasskan beberapa undang-undang lain. Okay, then we go to judicial decision. Okay, class. After this, do you have class at 4? Do you have class after this? No. Can we have 15 or 20 minutes extra? Okay, so tomorrow we will not have any class. Okay, because I have a meeting at 2:30. Okay, so kalau I buat kelas macam setengah jam je untuk besok. So can we finish some of the part, okay, regarding to the for example untuk unwritten ke kita boleh selesaikan hari ni. Okay.
Doctor,
Yes.
sorry, I have something on after 4 p.m. So is it
Okay, you
okay
have.
if I request for my friend to record for the other parts?
Okay, can? Boleh?
Thank you.
Okay. So the rest, yang lain ada lagi, ada hal lain. Only Atika je. Okay, so for the rest, who have no class and also have no other appointment, okay, could you please stay for 20 minutes, okay, around 20 minutes lah. Okay, Okay, judicial decision. We go to the judicial decision. Judicial decision is the decision by judge, and the decision by the previous judge later on will be considered as precedent and will be followed by the current judge who are sitting right now lah. Okay, keputusan yang dibuat oleh hakim yang lepas akan diikuti oleh hakim yang terkini bila buat keputusan. Okay, this is normal. If you look at the kalau kata you nampak the scenario of a lawyer yang bila pergi court kan, they bring big bag, kadang-kadang bawa bag trolley. Dalam tu adalah all the evidence and also all the previous cases yang dijadikan rujukan. Okay, kes-kes yang dijadikan rujukan untuk support their argument. Okay, because in deciding a case, we have to refer to the previous case. Bila nak buat keputusan ni, kita akan lihat kepada kes yang lepas. Ada tak kes yang lepas which are having the same fact and also the same scenario. Okay, fakta dia sama atau tidak. Supaya dijadikan rujukan untuk membuat sesuatu keputusan. So, and that concept, okay, that concept known as doctrine of binding judicial precedent. Bila mana judge nak buat keputusan, dia akan refer to the previous precedent, okay, as a guidance. So that concept known as doctrine of binding judicial precedent. Kalau dalam bahasa Melayunya, doktrin duluan kehakiman yang mengikat. So keputusan yang dibuat oleh hakim yang lepas will be bind the current judge to decide accordingly, to decide based on what has been decided by the previous judge. Okay, judge yang buat keputusan pada hari ini, hakim yang buat keputusan pada hari ini akan membuat keputusan sama sebagaimana yang diputuskan oleh hakim yang lepas. Okay, kena ada reference. So for doctrines of binding judicial precedent, normally it refer to the superior court, okay, superior court judge. So in Malaysia we have two level of courts. We have subordinate court and also superior court. Okay, subordinate court consists of magistrate, session court, okay, mahkamah yang kita anggap sebagai mahkamah bawahan lah, and also court of child or juvenile court. Nama lama dia juvenile court, sekarang ni court of child panggil. For superior court, okay, superior court consists of high court, appeal court, and also federal court. That one is superior court. So whatever been passed, whatever been decided by the court, by the judges from the high court, appeal court, and also federal court will be followed by the current judge. Okay? Will followed by the next judge who are sitting, okay, in that court lah. Okay, hakim yang terkini akan buat keputusan berdasarkan hakim yang lepas. So the decision of higher courts bind lower courts. And two types of precedents. Again, we name it as declaratory precedent and also original precedent. Declaratory precedent, where a judge applies an existing rule of law without extending it. In the declaratory precedent, okay, duluan asas kita panggil dia, di mana a judge, hakim akan buat keputusan sebagaimana hakim yang lepas. A judge applies an existing rule of law without amendment, tanpa ada pindaan. Just apply whatever been decided by the previous judge. Judge yang sekarang ini buat keputusan, dia hanya mengikut sahaja apa yang telah diputuskan oleh hakim yang lepas. That one is a declaratory precedent. Meanwhile, original precedent, okay, if the case before him is without precedent, if the judge right now, okay, when he want to decide, he Google, he go through all the case yang pernah berlaku, tak ada satu case pun sama dengan case yang berlaku pada hari ini, ataupun dia merasakan keputusan hakim yang lepas itu ada kesilapan. Okay, normal lah, sebab manusia yang buat keputusan kan. So the mistake can happen there. Then the judge who are sitting right now will decide, okay, based on justice, equity and also good conscience. Hakim yang akan buat keputusan sekarang ini, manakala dia tak ada presiden, tak ada panduan yang lepas untuk diikuti, maka dia akan buat keputusan sendiri bergantung kepada keadilan. Okay, justice, equity and also good conscience based on his own merit. So ada dua, okay, two types of president. And now we want to look at the hierarchy of court. Okay, so kat sini boleh nampak, okay, we have subordinate court and also superior court. Okay, so for subordinate court, we have penghulus court, magistrate court and also session court. Okay, penghulus court, okay, the ataupun district court lah. Okay, penghulus court ini akan diadili oleh penggawa. Okay, penggawa, ada setengah tempat yang ada penggawa lah, ada setengah tempat tak ada. Look at ada setengah negeri yang ada jajahan, yang ada distrik, ada daerah. So ada penghulus court. Tapi ada juga negeri yang tak ada jajahan, yang tak ada apa ni, yang dia tak bagikan tempat tersebut ada jajahan ataupun daerah. So dia tak ada pegawai daerah ataupun penggawa. So tak adalah penghulus court. So ada setengah tempat ada. Okay, and then we have magistrate court. So magistrate court will handle case yang bernilai 10,000. Okay, case yang kata kalau kata dikenakan tindakan tidak melebihi 10,000 lah. Ataupun claim tuntutan, okay, someone pinjam wang daripada orang lain. Okay, A of B 8,000 ringgit. So the case can be bring to magistrate court. Okay, bila mana B minta bayaran daripada A gagal untuk bayar sebanyak 8,000 ringgit tadi, then the case will be bring to magistrate court. So magistrate court only entertain the case will not, which not tidak melebihi 10,000 ringgit claim tuntutan tidak melebihi 10,000 ringgit. Meanwhile for session courts, case yang melibatkan 100,000 ringgit. 100,000 ringgit dibawa ke session court. Tapi selebih daripada tu, the case will be handled by high court. Okay, high court. Jadi kalau tak puas hati, okay, when the case been decided at the high court level, if someone not satisfied with the decision by the judge, he or she can appeal to court of appeal, then bring it to federal court. Federal court ni the last resort. Dah tak ada talian hayat dah. Ya, dah tak ada talian hayat at this level. The federal court, if in high court, the judge who's sitting, okay, for high court and also court of appeal, only one judge. But when it comes to the federal court, the judge who's sitting in a case consists of 3 judges. Consists of 3 judges. Ada 3 judge yang akan buat keputusan at the level of federal court. Kalau high court dan juga court of appeal, seorang je hakim. Tapi sampai dekat federal court ni akan ada 3 judge untuk sit for one case. So beside of all of this court, okay, kalau we nampak tadi, we have put a division. Okay, subordinate court, mahkamah rendah, consists of penghulu, magistrate court, session court. Penghulu ni case-case yang very small case lah, very petty case. For example, case hilang lembu bila sampai musim Hari Raya Korban, esok Hari Raya Korban, tiba-tiba lembu yang nak digunakan untuk korban besok hilang. Kes hilang lembu dan sebagainya boleh dituntut di penghulus court lah. Okay, very small case. And then when case yang melibatkan tuntutan tak melebihi 10,000, then we go to magistrate court. Magistrate court ni dia ada first class magistrate court and also second class magistrate court. Seterusnya we have session court. Okay, session court. So session court, magistrate court and penghulus court dianggap sebagai mahkamah bawahan. Okay, mahkamah bawahan, subordinate court, and the upper level of court known as superior court, i.e. high court, court of appeal and federal court. Beside of all of this court, this one we refer as civil court system. Civil court system. Beside of this court, we also have a special court. Kita ada mahkamah khas. Okay, for example, juvenile court. Okay, nama dulu juvenile court, but right now we change it. Okay, we change it to court of child. Kita kenali dia sebagai court of child. So untuk mahkamah kanak-kanak ini, the case will be held in camera. In camera means that no one can take picture. Okay. Kalau kata you pergi ke mahkamah Joanna, kes yang membicarakan kanak-kanak, court for children ni, court for children, no one can take picture or reveal who involved in that case. Tapi sekarang ni, sekarang ni masalahnya benda viral cepat. Kes yang melibatkan kanak-kanak pun tiba-tiba belum lagi dibawa ke mahkamah, belum lagi dibicarakan, dah tersebar gambar kanak-kanak tersebut. If you follow kes yang berlaku di Malaysia lah, if you still remember, pembakaran pusat tahfiz, ada satu pusat tahfiz terbakar. Dan who involved in that fire tu? Siapa yang buat, siapa yang startkan, mulakan kebakaran tu? Orang dewasa ke kanak-kanak? Yang later on, bila dibuat siasatan, siapa yang terlibat? Still remember tak? Tahfiz di Selangor yang terbakar. During tahun bila ya? 2018 or 2019, if I'm not mistaken. Pelajar sekolah. Ya, pelajar sekolah lah, pusat tahfiz. 20 lebih. 20 pelajar tahfiz age 8 hingga belasan tahun yang meninggal, and then later on find out that yang memulakan fire, kebakaran kepada pusat tahfiz itu ada 5 kanak-kanak. Anak-anak bawah umur. Dan apa yang berlaku, gambar mereka kemudian tersebar. Okay, so in fact, kes yang melibatkan kanak-kanak, and later on the case will be tried. Okay, kes akan dibicarakan di court for children. Nama ataupun gambar kanak-kanak tak boleh disclose kepada umum. Okay, because that one is principle in the court for children. So, kes tersebut mestilah dibicarakan in camera, tak boleh didedahkan kepada umum. Okay, so mereka ni, we know that for kes yang melibatkan kanak-kanak, salah mereka macam mana dalam kes tersebut melibatkan kematian. Okay. Memulakan kebakaran dan kemudiannya berlakunya kematian kepada beberapa pelajar tahfiz, around 20 if I'm not mistaken. Kena buka balik cerita tu lah. You can Google. Walaupun menyebabkan kematian, tapi kes berpunca daripada kanak-kanak, punishment dia tak sama dengan orang dewasa. Okay, mereka hanya dihantar. Okay, mereka kemudiannya dibicarakan di court for children dan kanak-kanak tersebut dihantar ke sekolah pemulihan akhlak Henry Kenny. Tak dihantar, tak di sentence, kes dibicarakan di high court untuk dijatuhkan hukuman mati ke, tak ada. And beside of court for children tadi, we have royal court, okay, mahkamah untuk raja-raja, royal court khas, okay, exclusive for sultan, not royal blood, bukan kerabat raja, only for sultan. Maisuri pun kena bicarakan dekat mahkamah biasa. Okay, royal court only exclusive for YDPA and also sultan sahaja. Okay. So there are several case lah kat Malaysia ni, ada case yang berkaitan dengan sultan yang dibicarakan di royal court lah. You can Google case berkenaan dengan almarhum Sultan Ismail Kelantan, bila mana that sultan bawa lari Lamborghini tak bayar cukai. Okay, the case kemudian dibawa ke mahkamah. Kemudian dibayarlah cukai. Bila the case dibawa ke mahkamah, dibayar cukai tax Lamborghini tersebut lah. Case bawa lari kereta, tak sempat bayar cukai lagi, dah guna pakai. And then case berlaku kepada almarhum Sultan Iskandar Johor, a few case. Banyak case lah dibawa berkenaan they refer to almarhum Sultan Iskandar ni. Case Prebet Adam, you can Google, okay, case ni. Case Prebet Adam, case Tanpa Mufti, case almarhum Sultan Iskandar dengan pemain hoki. Okay. Ada beberapa case lah dibawa in royal court, okay, berkaitan dengan sultan. And then beside of a royal court, we have industrial court. Industrial court, mahkamah perusahaan, industrial court. So this court will entertain the case which relates to employer and employee. because we know that the case for the case involved employer and employee, they have a special privilege, okay. So that's why ada industrial court. Bila mana kes yang melibatkan pekerja dan juga majikan under the industrial relation law, under the apa ni kita panggil undang-undang buruh lah, okay. Undang-undang perhubungan industri. There are several mechanisms being provided by that law, okay, to the employer and also employees. Bila mana ada dispute, okay, between the employer and employee, kalau kata pekerja tak puas hati dengan majikan, they have certain right. They can request from the HR to handle a meeting where HR will be the middle person yang akan mendengar kedua-dua belah pihak lah. Apa luahan hati pekerja, apa luahan hati pihak majikan. Okay, so there will be a round table meeting, okay, where the HR will be a mediator. And then if the solution cannot be found during the round table meeting, so the employees can do a picket before strike. Kalau picket ni, picket adalah mogok yang kecil. Nama dia picket, P-I-C-K-E-T. Okay, picket before. Kalau yang besar sikit kita namakan dia mogok ataupun strike. Okay, this one is picket and then strike is mogok. So for picket, not less than 10 person can gather, okay, in front of the office. Kalau kata 8 pekerja tak puas hati, so mereka gather in front of the office to show that, okay, they are not satisfied with the management or not satisfied with the employer. So mereka berada kat depan pejabat dengan spanduk dan sebagainya lah, menunjukkan bahawa mereka tak puas hati. So this picket sekiranya dibuat mestilah dalam keadaan aman dan tidak mengganggu jalan keluar masuk office. They cannot block, okay, people to come in and out from the from the company. Tapi kalau strike boleh dibuat dalam apa ni, a big figure, dalam number yang besar, boleh berkumpul beratus-ratus orang untuk buat strike. Dan bila mana strike dibuat, mogok dibuat, maka the company will be shut down. Company ditutup. That one is strike, itu mogok. Beza di antara mogok dan piket. This one is right. Kita membicarakan tentang hak pekerja. Dan beside of these rights, okay, pekerja also can have go slow. Go slow ni, okay, go slow also is considered as one of the mechanism to show that the workers not satisfied with the management. Go slow maksudnya datang kerja, okay, datang kerja, onkan laptop, onkan kamera, or onkan machine tapi tak buat kerja apa-apa. That one is go slow. Slow je datang, secara perlahan. Okay, so all of this is considered as to show the manifestation that they are not satisfied, not to show the protest, okay, to the upper level of management lah. Nak tunjukkan bahawa mereka tak puas hati. So all of this is considered as a right of the workers. Adalah merupakan hak pekerja. Cuma ada a few procedure have to go through before diorang buat strike ke, piket ke, go slow ni ada prosedur tertentu lah. Ya. Jadi kalau kata perbincangan telah dibuat di meja bulat, tak capai kata sepakat, then they can take several industrial action, okay, to show their protest. So the last resort, bila tak puas hati, dah buat dah strike, dah buat everything yang kita katakan sebagai industrial action, tak puas hati, then go to industrial court, mahkamah perusahaan. So that one is the last resort. Mahkamah yang akan membicarakan kes-kes yang melibatkan hubungan di antara majikan dan juga pekerja. Beside of industrial court, okay, beside of industrial court, tadi kita bicara royal court, we have court for criminal, industrial court, we also have martial court. Martial court, mahkamah khas untuk askar sahaja. Martial court. Okay, martial court. So, kes yang melibatkan askar, dia tak dibicarakan, tak dibicarakan di mahkamah biasa, they will trial in martial court. Jadi kes-kes for example ada dispute di antara askar, ada askar tertembak mati kawan dan sebagainya. So the case will be bring to the martial court. Okay, mahkamah askar. And beside of this special court, we also have a certain tribunal. We have kita ada tribunal perumahan, housing tribunal, and we also have consumer tribunal pengguna. Jadi kalau kata beli rumah tak siap, so boleh bawa tuntutan ke tribunal perumahan. Beli rumah, kemudian developer lari, pemaju lari, or the house boleh beli rumah, bayar dengan bank, tapi dekat tapak rumah hanya ada 2 batang tiang sahaja. Projek terbengkalai. So then bring to the housing tribunal. And for consumer tribunal, if the claim for tribunal pengguna up to 25,000. If you right now we know that saya rasa kebanyakan you all semua sekarang ni pun dah dianggap sebagai online consumer kan, pernah beli barang secara online. So sebenarnya bila kita beli barang secara online, we are exposed to certain threat lah. Kita terdedah kepada beberapa ancaman because sometimes we not know who are the traders. Kalau kata kita kenal trader tu, peniaga tu adalah kawan kita, tak apa, ataupun someone yang kita betul-betul kenal, saudara ke, tak kisah. Tapi selalunya kita beli barang ni pada orang yang kita tak kenal pun siapa. And then ada juga online traders who are not registered under SSM. So kalau kata ditipu, okay, we can bring the case to consumer tribunal. Okay. So online traders ni dia tak ada alamat khusus pun, dia tak ada premise yang kita boleh cari dia kat mana, unless they are registered. Kalau kata they are registered, then adalah kita can file, and then SSM record tu akan tunjukkan alamat terperinci the online traders. Because bila melibatkan pembelian secara online, we cannot touch, we cannot touch, and we can see the goods, okay, through the appearance dalam website ke IG ke dalam Facebook whatsoever. We cannot touch, and also we cannot smell lah. Macam tu lah, kita tak boleh pegang, kita tak boleh bau. Okay, kita boleh lihat, tapi the appearance sometimes can be misleading. Sometimes barang yang kita nak, colour dia tak sama sebagaimana ditunjukkan dalam website. Okay. Bila picture dia ambil, warna lari dan sebagainya. Okay, so kita katakan colour also can be misleading. Okay. So case kalau you ada claim, okay, berkenaan dengan beli barangan tak dapat, atau dapat barangan yang tak sepatutnya, ataupun late of delivery of goods, can bring to consumer tribunal. Just pay RM5 to open the file. Nak buka file tu just bayar RM5 sahaja. And for tribunal pengguna, okay, consumer tribunal, you will be you yourself will be a lawyer lah. Tak perlu hire lawyer luar. Okay, sebab kita sendiri akan bawa case. Kita akan bawa all the evidence. Kalau kata kita dah beli barang, receipt dia semua ada, bukti pembayaran dan sebagainya, kita print dan kita tunjukkan bahawa kita beli barang apa, sampai barang apa, barang yang tak sepatutnya dan sebagainya. So kita nak tuntut balik daripada penjual. Okay, so in the consumer tribunal only have a chair of consumer tribunal, ada pengurusi saja. Dia tak ada judge, ada pengurusi saja. And then we will present ourselves, yeah, and we also will be a lawyer. Okay, kita akan tunjukkanlah all the bukti, kita akan all the evidence, and also we also have to prepare our argument. And then the other party pihak yang satu lagi. So kalau kata dia ada parti tak datang, and then chair of the tribunal akan keluarkan satu surat bahawa dia ada parti or defendant dalam kes ini perlu membayar sekian-sekian kepada plaintiff, dan sekiranya gagal, kes akan dibawa ke magistrate court. Selalunya macam tu. Tapi kalau kata kes tersebut claim melebihi RM10,000, then the case will be bring to session court. Sebab magistrate court only handle 10,000. Okay, RM10,000 of case lah. So anything that you want to ask about the hierarchy of court, class? All clear about the tribunal, special court, and also about the civil court system. Okay, then we go to, okay, right now we want to look at the exception. Okay, just now we discussed about there are two types of precedent. Okay, declaratory precedent and also original precedent. Declaratory precedent, where the judge will decide based on whatever been decided by the previous judge, no amendment, no extension to that, no, without extending anything. Okay. Meanwhile, for original precedent, the judge will decide according to okay, based on justice, equity, and also good conscience, and also based on his own merit. So exception, okay, exception where the judge, okay, where the judge can decide otherwise. Walaupun kita katakan bahawa judicial decision ni maksudnya judge pada hari ini akan buat keputusan sebagaimana hakim yang lepas, follow the precedent. Tapi judge juga boleh buat keputusan sendiri. Okay, exceptionnya ada 3. Okay, there are 3 exceptions, so please highlight. When there are 2 contradict decision, bila mana ada 2 keputusan berbeza. Okay. Once judge ni nak buat keputusan, bila dia buka, okay, journal, CLJ, MLJ, all the compilation of journal, dan lihat bahawa ada 2 keputusan berbeza. Ada satu keputusan salah, ada satu keputusan innocent. Okay, merujuk kepada parti yang terlibat. Jadi, judge who are sitting now, they have rights, okay, to give their own decision. Dia akan buat keputusan sendiri, sama ada dia nak follow keputusan A ataupun follow keputusan B, ataupun dia buat keputusan sendiri. And second, inconsistent with the House of Lords decision, bercanggah dengan 2 dewan, iaitu Dewan Negara dan juga Dewan Rakyat. And then third, decision was given per inquiry. The judge who are sitting now, okay, later on when they go through the case, find out that there are mistake, ada kesilapan yang dibuat oleh judge yang lepas. So the decision was given per inquirium. Per inquirium to refer to mistake, ada kesilapan dibuat. So the judge now will make a rectification. Dia buat keputusan yang barulah, dia rectifykan keputusan yang lepas tersebut dan buat keputusan baru untuk kes pada hari ini. Dia tak follow lah sebab ada mistake. So normal lah sebab yang buat keputusan itu adalah manusia. Cuma in Malaysia, we don't have any law which give damages or compensation to person who receive a mistake judgment, receive kita katakan mangsa ataupun pesalah yang menerima keputusan yang silap dari mahkamah. Tak ada akta di Malaysia ni yang memberi pampasan ataupun ganti rugi kepada pesalah tersebut. Kita tak guna pakai akta tu. Kalau di UK ada. UK maksudnya kalau kata diberi salah keputusan, judge buat keputusan silap, sebenarnya dia tak salah. Actually he is innocent, but during the trial, memandangkan dia dapat lawyer yang tak bagus dan all evidence menunjukkan bahawa dia yang salah, tapi later on ada evidence baru yang menunjukkan bahawa dia adalah dalam situasi seorang yang tak bersalah. Sedangkan dia dah berada dalam penjara 5 tahun. So the court, okay, in UK dia akan bagi pampasan kepada orang tersebut. 5 tahun tu dikira ganti rugi orang tersebut berada terkurung dalam penjara katakanlah hilang kerja, hilang family, reputasi dia di luar, nanti bila dia keluar orang akan lihat dia still sebagai orang yang bersalah walaupun sebenarnya dia tak bersalah. So all of that will be counted, and the court, okay, the court mewakili government akan bagi ganti rugi kepada orang tersebut. But that law not apply in Malaysia. Okay. So I think that's all about decision of Commonwealth country. Okay, this one kita tak berbincang lah, not binding. Okay, so for decision of Commonwealth country ni maksudnya adakah keputusan yang dibuat di negara Commonwealth, di court, di mahkamah di Commonwealth country yang lain will be applied to Malaysian situation. For sure lah, not binding. Okay. Situasi di negara lain, even nama dia juga Commonwealth country, tapi budaya, custom dan juga whether they are applying Islamic principle ataupun tidak, menyebabkan keputusan yang dibuat di mahkamah lain walaupun di negara Commonwealth ianya tidak binding, not binding, only persuasive. Means that we can refer, okay, as a reference, but doesn't mean that we have to follow strictly. Okay? Doesn't mean that we have to follow strictly. So this has been decided in the case of Jamil bin Harun versus Yang Kamsia. Okay, so I think can we stop there, class? Kalau panjangkan lagi pun you tak boleh nak absorb dah ni. So we left the Islamic law, okay, and also custom. Okay, maybe in the next class we can settle the Malaysian legal system. Okay, following week selepas itu kita akan ada quiz lah. Okay, lepas kita selesaikan Malaysian legal system. Okay, so sementara tu you boleh baca, okay, boleh baca dulu mana-mana buku berkaitan dengan Islamic law, okay, dan juga kan boleh Google info ke dulu kan, before we meet next week. Okay, so please everyone, siapa yang tak sign up lagi, please sign in your attendance via Google Form in e-learning. So thank you everyone.